একটু সময় দিবেন আমাকে, just give me 1 minute. Court officer, you can start. Fahim, you can start.
Assalamu alaikum, your lordships. This is Fahim Sharia. Today, I'll play the role of court officer. Your lordships, if you grant me the permission, then I'll start the formal session.
Yes, please.
Much obliged, your lordships. All rise. Good evening. The Court of Appellate Division of the Supreme Court of Bangladesh is now in session. The case concerning today is a dispute between the appellant, Mr. F. Rahman, and the respondent, K. Sharkar. Both sides have 15 minutes to present their case and 3 minutes for rebuttal and sub-rebuttal. Now, I'd like to request the appellant to submit their pleadings. Submission.
May it please the court?
Yes, please.
Much obliged. Your Lordship, it's an honor to appear before this court today. I'm Amri Share Sharkar, appearing with my co-counsel Salen Tarek Ami. We appear on behalf of the appellant. I will take up 5 minutes of the court time for the first charge, and my co-counsel take 8 minutes for the remaining charges. We will reserve 3 minutes for the rebuttal. And the appellant said this case in this court by the jurisdiction of the Article 103 of the Bangladesh Constitution, because under this, appellate division shall have jurisdiction to hear and determines appeal from judgment, decree, order, sentence from the High Court Division. Before I start my submission, would you Lordship require to brief summary about the fact? Much obliged, Your Honor. In this case, Mr. Rahman hired Mr. Sharkar, a local builder, to rebuild his property in Banani on February 2021. According to Mr. Sharkar, the whole cost of the construction is 18 lakh. Rahman accepted the offer, and K. Sharkar started the construction work to be completed before the 5th April. After that, in the middle of the February, due to bad weather, plasterer Fosdar had go to an operation. Sharkar feared he wouldn't able to complete the task before the 5th April. So he advised Rahman that the price had to be increased by 5 lakh for the contract and add extra employee. Rahman was shocked, but his main concern was to complete the work in time. So he agreed. Sharkar completed the project before 5th April. In 2nd April, he sent a bill to the F. Rahman is that 3 lakh taka he demand as a consideration money. But Rahman said that he had some financial difficulties, so he can only pay 20 lakh takas. Sharkar agreed with that, and Rahman gave him 20 lakh takas with 10 kg rasmalai as a thank you. Sharkar in July see that Rahman has enjoyed his life in Cox's Bazar with his family in a 5-star hotel and spent a luxurious life. After that, Sharkar is angry and he demands his extra 3 lakh money as a consideration money with some interest. But Rahman denied to give his monies. Then Sharkar made a decision to sue against Rahman. If you had no further queries on the fact, I would like to go my submission.
Carry on.
Much obliged, Your Honor. Your Lordship, in our first submission is that in the issues whether the payment a lesser sum together with some additional goods 10 kg rasmalai in this case is sufficient consideration for creditor promise to forgo the balance. First of all, on this case, the appellants humbly submitted that the exceptions of the penal case, because on this case, it said that the payment of lesser sum together with some additional goods like horse, robe, etc. is a valid consideration if the additional things it benefited for the promisee and promisee accepted it. So on this ground of this case, appellant want to establish two grounds. Number one, the consideration is accepted or not, and number two is the additional things is benefited for the promisee or not. For the first thing, consideration is accepted or not. I would like to Your Lordship, I would like to your attention on the paragraph number 3, line 1, and last line is that Sarkar demand 23 lakh taka as a consideration money, but Rahman gives him only 20 lakh taka and with 10 kg Rasmalai as a thank you. But Sarkar accepted without any objection. Generally, when we analyze many cases, we can say that promisee give a lesser sum as a consideration money and promisee accept it. It doesn't mean that promisee accept a smaller sum as satisfaction debt. But there had when additional something is given and which is accepted by the promisee, we can say that these things is accepted as a valid consideration because these things is reflected on the Dunker LJ in D and C builder versus Reyes case. On this case, we find that the payment of lesser sum to amount with some additional good, which is satisfaction for the promisee, these things is consideration as a valid consideration. These things is also reflected in the first versus Beer case is that something extra which is given to the promisee as a lesser sum money is things also consideration as a valid consideration. Now, the appellant want to go to the second thing which we want to establish. Is the additional thing is benefited for the promisee or not? For these things, Your Lordship, I would like to beg your attention on the paragraph number 3, last line. Here we see that promisee get only 20 lakh taka with 10 kg Rasmalai, and when I would also beg your attention on the paragraph number 4, first line, that he can claim his objection on the July. Between these 2 months, he cannot say anything about the extra 3 lakh takas which he didn't get. But after that, when he see the Facebook post of the luxurious lives of the Afroman, he claimed his 3 lakh taka. But in between these 2 months, he can consume the 10 kg Rasmalai without any objection. When goods is usable as a consumer and he had no objection about the goods, it means that goods are beneficial for that person. Something is also happened on this case also. 10 kg Rasmalai is consumed by the K. Sarkar and as a enjoyable his for himself, and he didn't give any objection. So these things is beneficial for himself. And we can also give this a legal analysis on these things. William versus Roseborough's case, on this case also reflected that when the consumer get practical benefited from the valid for the any goods, these things is considered as a valid consideration in the eye of law. On the basis of these things, we can say that K. Sarkar enjoyed 10 kg Rasmalai in between 2 months, and he enjoyed the 10 kg Rasmalai properly. So there's things he didn't claim anything about his 3 lakhs taka. So by this 10 kg Rasmalai, he get practically benefited, and the payment of lesser sum together with some additional 10 kg Rasmalai here is sufficient as a consideration, and promisor need to get or give any extra balance for this others. And now, Your Lordship, if you have no further queries regarding my submission, I would like to rest off here, and I would like to invite my co-counsel for further submission.
I have a question, Learned Counsel.
Much obliged.
In this given scenario, what sort of contract are we talking about? Is it a contract where you are simply claiming a sum of money as a debt, or it is a contract based on supply of services?
Much obliged, Your Lordship. It's based on services because K. Sarkar said that he finished his construction within 5th April and all the materials and monies give himself by this 18 lakh taka. On the basis of these things, they had a contract.
Right. So my collateral question or supplementary question to this is, do you think that the rule in penal's case that, the payment of a lesser sum of money cannot satisfy the claim for a greater sum of money, Actually, do you think this has any application at all in this given case? Do you know of any authority where something else was said?
I beg your pardon, please say the question. Repeat.
My question is, when you are suing on a sum of money, which is payment, like you're saying, the payment of lesser sum of money, right, cannot settle the claim for a greater sum of money, the rule in Pinel's case. My question is, do you think the rule in the Pinel's case should be applicable in this given scenario? Because this is a contract for supply of, let's say, services. Like you mentioned, William versus Roffey Brothers. Right.
Yeah, Mark,
So
yes.
William versus Roffey Brothers was what kind of case? Do you recall?
It's a contract for the services also.
Good. So Roffey Brothers was a contract for the service case, and this is also a contract for the supply of service case, right?
Yeah.
Okay. Thank you. That was my question. Thank you. Please carry on.
With my learned brother, I want to put up another question to the presentator, my lord. Presentator. The question is that can you show us a statement regarding that the Rosmalai was accepted by the defendant? Rosmalai, can you show it from the paragraph 3? Can you show it?
Much obliged, your lordship. On the paragraph 3, I beg your kind attention on the paragraph number 3, line number 3. Here, Sarkar thought that better accept 20 lakh takas end up nothing at all. Nothing at all, but he accept the 20 lakh takas, and as a thank you, when 10 kg Rasmalai is given to him, he also accept it with 20 lakhs taka. Your lordship.
But Mr. Roman only sent it to to Sarkar, but that was not accepted. From the fact, it is not clear that is whether it was accepted or not. Can you show it by any document or from any statement?
Much obliged, your lordship. Your lordship, on the things, on the given scenario of the fact, we also see that there is no any regarding these things. The Sarkar refused to accept 10 kg Rasmalai. So when he by this scenario of the fact, we can see that he accept 20 lakh takas, and with 20 lakh takas, when Sarkar give 10 kg Rasmalai, we also presume that with 20 lakh takas he also accept 10 kg Rasmalai. Your lordship.
Yes, thank you. From fact, it is not clear. Actually, from the facts, it is not clear whether it was accepted or not. But it is
much obliged, your lordship. But fact is said about accept 20 lakhs takas clearly. So because of 10 kg Rasmalai given with 20 lakhs taka, so he accept 20 lakh taka, and he also accept the 10 kg Rasmalai. We can appellant want to say it about this.
Thank you, learned counsel. You may proceed.
Okay,
Much obliged, your lordship.
I am Zakir Roshan Khan with my learned fellow counsel and adjudicator. I would like to put some question to the learned counsel of the appellant. What are the terms and conditions of the agreement in this case?
Much obliged, your lordship. Your lordship, in this case, terms and conditions is that the K. Sarkar complete his work between before the 5th April, and K. Afromans paid him 18 lakhs takas about these contracts.
This is the original contract, original terms and condition.
Indeed, your lordship.
And subsequently, was it changed or not?
Your lordship, in our appellant argument is that alteration of the contract or additional contract is not valid on that fact, because there had no material fact. There is just a negotiation between them about the extra 5 lakh takas or other things.
Okay, why are you reluctant to pay the 3 lakh, the rest amount of the money of this contract?
I beg your pardon, please repeat the question.
Why did you reluctant to pay the 3 lakh, the rest amount of money of the contractual agreement between the promisor and the promisee?
Your lordship, in our side, we can say that the appellant, my client, Afroman give 2 lakhs taka as a bonus or other things. So he didn't enter into the second contract, which is about 5 lakh taka. So he didn't ever oblige or any other authority, or he any other duty to payment extra 3 lakh takas. So he didn't payment or refused to pay extra 3 lakh takas on here.
But initial contract was between these two persons are in consideration of amount of 18 lakhs. Subsequently, 5 lakh taka were increased. And when the payment of 20 lakhs along with additional goods like Rosmalai of 10 kg, doesn't it mean to agree with the second term of condition of this?
Much
Yes.
obliged, much obliged, your lordship. If he agreed second contract or subsequent contract, we can also say that our respondent K. Sharkar claimed 3 lakh takas on that time as his rights, but he didn't claim anything his rights. He rights because he believed that the second contract is not valid. But after that, he can use these things as a position of the affirmance. So if he didn't say anything at that time, we can say that the contract is not valid, second contract is not valid. So K. Sharkar didn't demand the additional money which comes from the second contract.
Why you say that the second contract is not valid? Second contract term and condition are not valid because after completion of the contract, by building the contract in time, that means 2nd April, and delivering that same to F. Rahman is not the implication of by contract that they are under the agreement between the promisee and the promisors.
Much obliged, your lordship. These things are also comes in the first contract because first contracts also reflect that in 18 lakh taka they complete the work in 5th April, and in second contract they just negotiation that he need extra 5 lakh takas. But these works and duties for which K. Sharkar demand extra 5 lakh, these duties comes from him from the first contract. So because of these duties which he get from the first contract, my client Aframan did not oblige to pay extra any money for the same contractor obligation which already they contract for payment 18 lakh taka.
Okay, thank you. Carry on.
Much obliged, your lordship.
May it please the court. Your lordships, this is Salehin Tarek Omi appearing before the court with second and third issue, and I'll be taking 8 minutes of the court. May I proceed, my lordships?
Yes, you may proceed.
Yes, my lordship. The later variation of the contract to increase the amount of 5 lakh for the timely completion is not possible and enforceable under the law of contract. Appellant claims that the later variation of the contract to increase the amount of 5 lakh for the timely completion is not possible and enforceable under the law of contract. Some essential element of the alteration of contract is missing here, also of fair and free consent. So later variation of contract is not possible and enforceable under the law of contract. Your lordships, English law has already denied the possibilities that valid consideration can be found in performance by a contracting party of something it is already bound to do. This rule is called the so-called duty rules. So, such act and like alteration of contract explained by the fact it cannot be of any value in the eye of law. There has a renowned case, your lordships. I would like to pay your kind attention that Stilk versus Myrick, it was held that the claimant was under an existing duty to work the ship back to the London and undertook to submit all the emergencies that entailed. Therefore, he had not provided any consideration for the promise of an extra money. Consequently, he was entitled to nothing. From this ground, this case, it is transparent that without the alteration of contract, material document, and free consent of the parties, alteration of contract is valueless. I would like to draw your kind attention, your lordships, on section 62 of Contract Act 1872 that to be an alteration, there must be 2 elements for that. The alteration must be done deliberately, and the alteration must have materials. Alteration cannot be done unless both the parties is assented and done in mutual trust. Alteration in term of contract happens when the parties entered into a contract and one of the party wants to modify or change certain terms of the contract with the assent of the both parties. Hence, once the parties sign the contract, they cannot alter its term except in the case where all the parties mutual consent agreed to the alteration. I'd like to draw your attention on the case that Kameshwara versus Hemalant Maro. The court observed that a material alteration is one that varies the rights and liabilities of the parties ascertained by the deed or varies the legal effect of the instrument originally expressed. In this case, there is no document or any other sites to back the alteration of the contract. Judges did a negotiation which cannot be treated as an alteration of contract. Then come to the point of free consent. Free consent is one of those core elements of a contract. A contract without free consent is questionable under a questionable contract. Section 14 of the Contract Act makes it clear that no contract should be done under any pressure of undue influence. Any contract where there is a domination of one party should not be treated as a free contract. In this case, Sarkar already know that Mr. Rahman has already led the place to a renowned law chamber for a good amount of money, and his renovation have to be done in time to hand over the place to the chamber. So he did take advantage of the situation to gain some more money from it and put Rahman in such a position that he cannot say no to. This is the kind of pressure of undue influence which is declared void under the Contract Act on the ground of free consent and in contract. Now, my lordship, I would like to come to the point of the doctrine of promises.
I have a question, Lord Counsel.
Yes,
Since you're relying on English authority,
yes, sir.
Steele versus Merrick has been heavily distinguished in Williams versus Roffey brothers, right?
Yes,
so you are
sir.
aware of the case, definitely. So,
Yes,
I mean, how would you make your submissions on that issue? Because you are saying that you have to stick to the facts, right? The initial contract price was 18 lakh taka,
yes,
and then it was agreed that because of the difficulty, 5 lakh taka had to be paid more. So it was reluctantly agreed that you have to stick with the facts, right? So there was an agreement on the part that, okay, we will pay you 5 lakh taka. Now, my question to you that, I mean, if you stick to the elements of bargain, how would
Yes,
you place the doctrine or the, I would say, ratio of Roffey brothers case distinguishing Steele versus Merrick? Because Steele versus Merrick was a question of employment contract where the sailors left the ship, right?
Yes,
And remaining sailors had to renegotiate with the master.
indeed, your lordship.
Right? But Roffey brothers was a case of employment contract, and it was not a case of employment contract, rather it was a case of contract for supply of service,
Yes,
which falls squarely in the given set of facts that you are submitting on. So my question to you is, how do you treat the Roffey brothers ratio subject to your submission of Steele versus Merrick?
in that case, it was held that the employee should done their work, and which is they're entitled to do. And in here, at the same time, the first contract was done that he would done his work by in time in the same amount. And
Yeah.
which is why this, I think this reflect on the current fact that the Mr. Sarkar is entitled to do the work in the amount of 18 lakh taka, which is said in the past contract. This is how I think it was reflecting on the case. Your
Okay, so did your client that you're representing, did he not get any benefit because of the fact that they were finishing the work on time?
Yes, your lordship, I was getting some benefit indeed here because I have already let a place to a law chamber, which would have to be handed over in time, unless I will be facing some damages here.
Good.
And I was entitled with the contract that he would do the work done in time, in due time, your lordship.
Right. So would you suggest or would you submit that practical benefit may amount to consideration in some cases?
It depends and it varies from the case to case, your lordship. As become of the fact, we know that F. Rahman was doing bought this place in a half of price, and he made it kind of a business of himself, and he was trying to gain profit from that. So if he get the less money from that, he's ultimately falling in some damages, your lordship.
Deal from them. So it's going to know what the iPhones need.
Okay, thank you.
Yes, your lordship. May I proceed, your lordship?
Okay, learned counsel, I want to put up another question to you.
Yes,
That is,
lordship.
admittedly, you have paid 20 lakhs taka. It is
Yes.
admitted you have paid 20 taka, but your initial contract was about 18 lakhs taka.
Indeed.
In your argument, you are putting arguments on the points of undue influence, that is, without free consent, the agreement has been made out. But on the other side, you are from the facts, it is found that you have paid 20 lakhs taka. Since you have
Yes.
paid taka 20 lakhs, you cannot subsequently deny that amount and the subsequent contract. What is your argument on this point?
Your lordship, the 20 lakhs taka, the extra additional 2 lakh taka and 10 kg Rasmalai was given to them as a bonus because and as an appreciation, as he also know that there were some difficulties when they were working on the renovation and they have to put the workers some overtime and some extra workers. So he know that Mr. Sarkar might be facing some difficulties, which is why he just wanted give the 2 lakh extra taka and the 10 kg Rasmalai as a bonus to them, that he's happy with his work that he's done before that time, and even after they were faced difficulties in the time of renovating that home office, your lordship.
My question is, by your acts, you have shown that our earlier contract has been revoked and you have made a fresh contract, and as a proof, you have paid 20 lakhs. If
Indeed,
you did not pay the entire 20 lakhs or less than 20 lakhs or less than 80 lakhs, that the question could arise.
your lordship, I want to entirely that we are facing this case because we are saying that the alteration is not valid because there was not there was some lacking of the element for which the alteration cannot be done by the law of contract, your lordship. This is why we are fighting. This is why we are presenting our case in this court, your lordship.
Thank you. Thank you.
May I proceed, your lordships?
Yes, you may proceed.
Now I'll be talking about the establishment of a promissory estoppel. To establish a promissory estoppel, there have to be some significant ground and situation, like a significant promise to cause the promise to act on it, and a promisee suffered significant damage by relying on it. In this case, there is no significant promise on the rise of money. It was just a negotiation between two parties, which cannot be treated as a significant promise between them. A negotiation cannot be a promise, and so the ground of promissory estoppel cannot be established. When Rahman paid the amount of 20 lakh, giving his reason, Sarkar take it without any hesitation and did not make any complaint about the money, as if there was no damage on his part, which makes it clear that there was no damage on Sarkar's part, which with the amount of money he was paid, he accepted it joyfully. For getting benefits of a promissory estoppel, a person needs to fulfill the element of promissory estoppel, and promisee must suffer significant damage by relying on the promise. Is one of the most important element on here, but the respondent said it did not come out properly because the payment of previous employee can be given to the new. So if there is, if your lordship have no more queries, I would like to move to the prayer, your lordships. May I?
The doctrine of promissory estoppel is a creation of equity, right?
Yes,
so what does it expect? How the doctrine would expect a promisor to behave?
That the promisor should rely on his promise and fulfill his promise to the promisee, your lordship.
Right. So in this given set of facts, do you feel that the owner has behaved properly?
Yes, your lordship, because the owner was in a contract before and they were employee on because of that contract, and they will have to finish the work in time, and they were also contracted the amount of the money, your lordship.
Okay, no, what I'm trying to say, the owner means the owner of the site, not the contractor.
Okay. From
So,
your worship.
right, exactly. So my question to you that when would the doctrine of promissory estoppel operate, and are there any situations that you can tell that it might, I mean, you might just not get the equity that you're seeking for?
Your lordship, I think I have done the equity because I have already given them the money that we were contracted, and because of their work I have happy because they have facing some difficulties, and I have given some bonus with them with like 2 lakhs taka and 10 kg Rosmalai, which he happily and joyfully accepted them. Your lordship.
So in your view, the 2 lakh taka is a bonus and not a contract modification, right?
Yes, your lordship.
Okay.
Indeed.
Thank you.
May I proceed with my prayer, your lordships?
Okay, I am.
Yes, your lordship.
In support of our learned counsel, Dr. Khalid Chaudhary, the previous contract was 18 lakh, and lastly, after completion of the work, F. Rahman paid 20 lakh, but it was said that 2 lakh extra was not a continuation of the second contract, but it is a bonus only. But
yes, sir.
From the fact it is not clear, from the given fact it is not clear that it is a bonus or it is not the renewal of the second contract. It is very vague. It is very vague. So if we stand on your point that second alteration of the contract is not a valid contract, valid terms and condition, why you continue with the builders to carry out the agreement? It is a question, in fact. However, from previous answer and question, it is clear that it is a bonus, not a continuation of a contract. Okay, carry out. Thank you.
Indeed, your lordship. May I proceed with my prayer, your lordships?
Yes, please.
Whereof, in the light of the issue raised, argument and advance and authority cited, it is humbly prayed that on honorable court to declare the payment of lesser sum together with additional goods, in this case 10 kg Rosmalai, is sufficient consideration for the creditor promised to forego into balance, and to declare that the increased amount of 5 lakh for the timely completion is not possible and unenforceable under the law of contract, and yes, the doctrine of promises Estoppel should prevent the respondent recovering the rest of the money and pass any order, direction, or relief that this honorable court may deem fit in the interest of justice, equity, and good conscience. I rest my case, your lordships.
Now, the respondent may begin their pleadings.
Am I audible and visible?
Yes.
Thank you very much. May it please the court? Much obliged. Your lordships, I, Rubaiyat Jamila Manobi, alongside with my co-counsel Ankita Datta, will be presenting the respondent in this case, Mr. K. Sarkar, for the next 15 minutes. I would like to reserve the first 8 minutes for my submission and the next 7 minutes for my co-counsel's submission. If the court has no questions and queries regarding the facts and jurisdiction, may I proceed with my arguments?
Yes, you may proceed.
Much obliged. So I'm going to deal with the first issue and the first argument of the second issue in this court, your lordships. So the first issue in hand is that the payment of a lesser sum together with some additional goods, in this case 10 kg Rosmalai, is not sufficient consideration for a creditor's promise to forego the balance. My first argument on this issue is that 10 kg Rosmalai has no economic value and practical consideration to forego the balance. However, before moving on to my argument, I would like to draw your attention that our opponent team has said that the extra 2 lakhs taka was bonus. However, this is very evident in the moot compromise in the paragraph number 3 that their client said he is in financial difficulty and he cannot provide the whole amount of 23 lakhs taka. Therefore, he has sent the check of 20 lakhs taka. Your lordship, this proves that this was not a bonus, but they paid the 2 lakhs taka extra, 2 lakhs taka for their instead of the 23 lakhs taka. Now moving on to my argument, your lordship. At first, I would like to refer to the Profulla Kumar Chakraborty versus Anil Prasad Chakraborty case. In this case, the Honorable Court of Bangladesh has decided that waiver is a question of fact and is to be established in each particular case by the party desiring to raise this as a special pleading in this case, thus shifting the burden of proof to the appellant. The appellant has to prove without any doubts and without any questions that there was a waiver, and we are going to prove that there was no waiver from our client. So where a creditor accepts a part payment of a debt owed to them under a contract, the general common rule found in the penal case, later upheld in Fox versus Beer case, that there is nothing to prevent the creditor claiming the balance due to him at a later date. Also, if the seller agreed to accept part payment on an earlier date than the due date, then that could be construed as a sufficient for the purposes of fresh consideration. While we can say from the Moot compromise that after the completion and full performance of the case order, F. Rahman has paid the consideration, which is only 20 lakhs taka. Also, in the William versus Rofi case, they have to provide that there was a practical benefit, even if there was no benefit in the eyes of the law. The 10 kg Rosmalai, your lordship, has no practical benefit because it is perishable and cannot be gained any benefit in the future. Moreover, the more strict view of Fox versus Beer would apply, and benefits of receiving part payment itself not sufficient consideration. After all, part payment cannot be satisfaction of a greater sum owed. Now, moving on to my second argument on this issue is that the Rosmalai was only given as a thank you gift. It is very evident in the and agreed in the Moot compromise that the Rosmalai was given to Sarkar by F. Rahman in consideration of his kindness as a thank you. It was not requested or demanded by our client K. Sarkar as a part of it. Moreover, they have also agreed, our opponent team, about the penal case, and the gift of a horse, spoke, and robe, etc. is insatisfactory in good, but it shall be intended that a horse, spoke, or robe that might be more beneficial to the plaintiff and the money. So they have to prove that it was more beneficial, but a perishable thing which has no benefit in future cannot prove that. Also, Sarkar did not accept the gift of Rosmalai instead of the debt. There are certainly some grounds to say K. Sarkar can claim the balance now because he believes F. Rahman's financial position to have changed significantly for the better than it was before. Now, moving on to my last argument on this issue is that I would like to refer to the DC Builders versus Rees case, because in that case, the debtor similarly offered to pay a smaller amount of the total, otherwise the creditor could get nothing. Very similar to our case. Creditor accepts a check and later demands settlement in full. The court held that promisee could not operate as the promise was not freely given. Hence, it was not inequitable to go back on it. Moreover, your lordships, like the Rees family, F. Rahman did not advertise his dissatisfaction immediately. It is evidently present in the paragraph number 2 of the Moot compromise until the completion of the obligation made by the K. Sarkar. Your lordships, following the completion of the performance by K. Sarkar, when presented with a statement or bill for the payment of full sum, and respondent issues a check, much like the Rees family. And in the DC Builders versus Rees case, there was no binding settlement in between the parties, and the court held that in the same situation, there is no binding settlement for the creditor to let go his due balance. Now, moving on to my second issue, which is the later variation of the contract to increase the amount of
Counsel, sorry, I'd like to interrupt you. I have a question. Please allow us a minute. The question that I posed before, that do you see the difference here, the scenario of Pinal's case and the Rofi brothers case in this given situation? I mean, you have also relied in the, we have seen the memorial and stuff, the reselect move decision, right? Are you aware of the reselect move decision?
Yes, Your Lordship, yes.
My simple question is that this is a situation involving contract of supply of services, right? It's a building, construction, and etc. Now, Pinel's case applies when someone is simply suing for the money, when the money is owed by the creditor to the debtor, you know. So my question to you that do you think that the Roffey brothers doctrine should actually apply to Pinel's case at all? Because Roffey brothers is based on practical benefit, right? That case is based on practical benefit being given to the one party to the other. However, Pinel's case is not talking about the practical benefit, it's talking about simply a debtor-creditor trade. So how you would address that?
Much obliged, Your Lordship. I have referred the Pinel's case because it was stated in the moot compromise and also it was stated in the memorial of our opponent team. So I said that when they're saying talking about Pinel's case has also said that the whatever they are offering, it has to be more beneficial to the money, more beneficial from the money. And Your Lordship, for the case of the William versus Roffey case, I wanted to actually refer to this case also. If you allow me, I will say that in that case, there was involved the issue of consideration, and in particular, whether performing an existing contractual obligation, it was completing the carpentry work on time, which is very similar to our case, could constitute valid consideration for a promise to pay more money to ensure timely completion. Here, the Roffey brothers were liable to pay more money, which they had promised for the timely completion of work. Your Lordship, in this case, the Williams versus Roffey case actually very applies because the facts are very similar. Your Lordship, was your question?
Yeah, thank you for the reply. Please carry on.
Thank you very much. So my second issue on hand was the later variation of the contract increase the amount of 5 lakhs for the timely completion is possible and enforceable under the law of contract. So the first argument was for the timely completion, the variation of contract to increase the amount is valid, and I have already referred the William versus Roffey case. So I will move on to another case. This is a very recent English contract case which has been held in 2018, and the case is the Rock Advertising Limited versus MWP Business Exchange Centers Limited. Your Lordship, in this case, the Court of Appeal held that the agreement to vary the contract was supported by consideration. And we can see that the facts are very similar, the circumstances are very similar with our case. MWB would receive many benefits from the rearrangement. Rock would remain in occupation of the premises like Kesharkar, and MW would not have to find a replacement like F. Rahman. So the judge endorsed a similar outcome. The judge emphasized that a promise to vary a contract can upheld. It was also held in William versus Roffey case, where the promisor receives an additional benefit. The benefit, which you actually mentioned, Your Lordship. So the benefit in MWB being that MW avoided the void of having to replace Rock as a tenant, which is very similar in our current fact. Also, something extra of value was satisfied in MWB, like the Pinel's case, and the MWB receiving the practical benefit of avoiding the hassle of having to find an alternative tenant. The overall conclusion arrived that there can be no coherent distinction between the agreements to pay debts and agreements to do work in this context. Your Lordship, it is clear that F. Rahman was in similar position of FWB and had same benefits like FWB, which shows that he actually received practical and additional benefits, and he must pay the rest of debt because it is a contractual obligation. Therefore, a later variation of the contract to increase the amount of 5 lakhs taka for the timely completion is possible and enforceable. I would not take any more time because I'm lacking of time. So I will rest my arguments here and would invite my co-counsel to give her submission.
I have one question.
Yes.
You have heavily relied on the Rock advertisement case. So do you think Rock advertisement case in the Court of Appeal, when it went to the Court of Appeal, did it actually support Roffey brothers or Roffey brothers was distinguished?
I will just take a moment to answer your question if it is okay.
It's okay. I'll make it easier for you. Look, Rock Advertisement was a case of licensing agreement. Someone was staying and not paying the areas of the rent. Okay. It was not a building construction contract.
Yes.
And the High Court judge in the lower court, it was thought there that, you know, by paying, by promising to pay the area gradually, right, it would be a practical benefit situation. So basically, they were distinguishing Rafi Brothers. And it is a risky distinction because if Rock Advertisement Court of Appeal or the High Court sustains, then actually Rafi Brothers would swallow up the Doctrine of Penals case. You understand? Rock Advertisement rather. And my final question to you is, do you know what happened when the case went to Supreme Court? When Rock Advertisement went to the Supreme Court? Are you aware?
No, I apologize for not having the knowledge, Your Lordship.
Okay, no problem. Please carry.
Okay,
Actually, I have raised my
I have a
argument.
question. I have a question to you. Very simple question. Whether there is any breach of contract? In this case, whether there is any breach of contract?
Your
Yes or
Lordship,
no?
I did not understand your question.
Whether in this case there is any breach of contract or not?
Yes, Your Lordship. To answer you that question, I would like to refer the section 72 and section 73 of the Contract Act of 1870.
How you say that there is a breach of contract when the greater amount of money already paid with additional goods? How did you say that there is a breach of contract?
Your Lordship, the non-payment of the outstanding amount is the breach. When in the I would also like to refer to the moot compromise, where it is clearly said that our client was in fear of not getting anything at all. So that's why he agreed initially on the 20 lakh taka instead of 23 lakh, not instead of 23 lakh taka. And he never.
It is clear, no doubt. But my question is on the point, when by your conduct or activities receiving 20 lakh taka additional goods along with additional goods, does it not mean that there is a performance of a contract? If it is a performance of a contract, you must say that this is a part performance of a contract, but you cannot say that there is a breach of contract. Clear?
Yes, Your Lordship. Thank you very much for enlightening.
Lord Counsel, please hear me a question and answer it properly. Admittedly, you have accepted taka 20 lakhs. It is admitted you have accepted taka 20 lakhs. After accepting the amount, whether you made an offer for paying the rest amount of 3 lakhs by any letter or any other mode?
Your Lordship, to answer that question, I would just like to refer two cases. First, the Phonics versus Mills versus MH Dinshaw and Company, and the MS Binning and Company, Bangladesh Limited versus MS Nasirabad Properties Limited. So in these cases, what happened? What case law was given that a promisee can only dispense with the performance of the promise by an affirmative and voluntary conscious act. Mere acceptance of a thank you gift as provided in the moot compromise is not sufficient to constitute a waiver. The essence of waiver is that there must be a voluntary and intentional relinquishment of the rights. We never accepted the Rosmalai as additional good to relinquish our right.
Lord Counsel, my question is there any proof or like any letter or any other mode you offer to pay the rest amount of money? Is there any proof in your hand or in the facts delivered to you?
We will pay the rest of the money, or they will, if Rahman pay.
Is there an offer?
Your Lordship, I apologize. I actually did not understand the question. Can you please repeat again? I apologize.
On the date of acceptance, whether you offered the defendant to pay the rest amount of money.
We are the defendant, Your Lordship. We are the
You are
respondent in this case.
in original suit, you are the plaintiff.
Oh, yes.
We are talking about the original suit. You
Yes.
have to bear in mind that you always have to mind that in original suit your position what you were or not.
Yes.
In original suit you are the plaintiff.
Yes.
And here in the appellate division you are the respondent. So you
Yes.
have to
Yes.
put your submission considering the plaintiff's case.
The fact is silent about this, but I would like to refer you to the
Okay,
paragraph.
thank you. I have got your answer. Okay, thank you. Fact is silent.
So I will invite my co-counsel, if you're satisfied with the question answers, to proceed with her submission.
Your Lordship, I would like to give two arguments on behalf of the respondent to establish that the respondent is eligible to get the additional 3 lakh rupees. Firstly, that the increased amount of 5 lakh rupees is applicable due to unforeseen difficulties. It is for the promisor to stipulate the consideration for his or her promise and not the promisee to offer something and call it consideration. Provided the consideration stipulated is legal, it can make virtually for any form, and importantly, it should be legal. Your Lordship, a commonly recognized exception to this foregoing rule is the so-called unforeseen difficulties doctrine, which permits an existing contract to be modified to account for unforeseen difficulties that arise during the course of the performance. Your Lordship would be kind enough to refer to para 2 of the Moot compromise, where it has been stated that Rahman Sarkar demanded the 5 lakh rupees just after entering into the contract, citing that due to bad weather and the absence of his plasterer. Your Lordship would also accept of the fact that during the following months, February, March, April, by 5th April, he was supposed to give the restored property to Rahman. March, April is the month where it is a stormy. We have evidence of stormy nights and the construction work gets hampered. So from the agreed facts, it is clear that K. Sarkar faced unforeseeable circumstances and had to raise the amount due to bad weather and replacement of Farzad. Therefore, these unforeseeable circumstances bound him to raise the money to 5 lakh, and it is possible and enforceable for the timely completion of the contractual obligation. Moreover, Your Lordship, the appellant in their submission has already said that they got an additional benefit as a timely completion for the restored property in their submission. Moreover, I would like to throw some light on the undue influence that the appellant has been claiming. Your Lordship, to fulfill undue influence, there must be two criteria. Firstly, that the parties are into a fiduciary relationship. It does not mean that they would be in a blood relationship, but it has to be a fiduciary relationship. But in this case, both were independent and there is no such relationship. And the other is that the other person to whom it is telling that the undue influence is being done should be mentally unfit due to reason of his age or disease for anything. But in this case, none has been fulfilled. Your Lordship, coming to the doctrine of promissory estoppel, it should be operated to prevent it should not be operated to prevent the respondent from recovering the rest of the money. Your Lordship, I would like to draw your attention to page number 12 of my appellant's memorial, where they have referred to two elements, but they haven't cited any source for it. Rather, Your Lordship, the counsel for the respondent would like to give 4 criterion as it was set in the High Trees case, which is known as Central London Property Trust Limited versus High Trees case. Before the case, the principle of promissory estoppel was first developed in Hughes versus Metropolitan Railway case, and it was absent for some time. But later on, in High Trees case, it was again prevailed. In this case, the House of Lords gave 4 basic criteria to be fulfilled to invoke the principle of promissory estoppel. And your lordship, this doesn't apply to Sarkar. Firstly, that the promise must be clear and unambiguous in its terms. Your lordship, Mr. Sarkar informed Mr. Rahman about the bad weather and his plasterer's operation and asked for additional 5 lakh taka to complete construction within the prescribed time. However, when the construction completed, Mr. Rahman could not pay the full amount due to his financial difficulties. As referred to by my co-counsel to William versus Rofi's case, it has already been proven that the additional amount Mr. Sarkar charges was appropriate. Furthermore, Mr. Sarkar never told F. Rahman that he would not claim the rest amount. Hence, the contract was very clear and unambiguous on the respondent's part, but the appellant lied about his financial condition, which is basically a breach of the first criteria. Secondly, reliance by the parties to whom the promise is made. The defendant did not make any promise to the appellant for not charging the rest of the money. There is no such points on reliance on the promise. Rather, Rahman paid reliance on the words of Rahman. Sarkar paid reliance on the part of Rahman that he would pay the amount rest of the 3 lakh money when he will be getting 1,20,000 taka per week for letting his office. Thirdly, that the reliance must be both reasonable and forcible. In this case, it was not so. The reliance was not reasonable and forcible because there was no such promise of the defendant's part. In the middle of February, which is of 2 months prior to the completion of the construction, Mr. Sarkar notified Mr. Rahman about the weather condition and he also demanded the 5 lakh rupees. Suddenly, after 3 months on July, he became financially capable of taking his full family to Cox's Bazar. Moreover, your lordship would be kind enough to note that the party asserting the Estoppel must be injured by his reliance. In this case, F. Rahman has not been affected in any way. I would like to cite U.S. Ecology Inc. versus State of California, where the court has said that to claim promissory principle of promissory estoppel, government, particularly where the application of the doctrine would further public policies and prevent injustice. From the Moot compromise, it is clear that Mr. Sarkar, after notifying Rahman laborers was in double shift, the expenses were increased, and he was very much right to claim 5 lakh rupees. Thus, your lordship, the counsel for the respondent pleads before the court to adjudge and declare that the payment of additional goods like Rashmalai is insufficient consideration for a creditor's promise to forego the balance, and adjudge and declare that the letter. I would ask your lordship for 30 seconds to give my prayer.
Please carry on.
Adjudge and declare that the latter variation of the contract to increase the amount of 5 lakh for the timely completion is possible and enforceable under the law of contract, and adjudge and declare that the doctrine of promissory estoppel should be inoperative to prevent the respondent from recovering the rest of the money. That's all, your lordship.
Okay, although you finish your prayers, I have a question. Firstly, how would you see Section 63 of our Contract Act to apply to this situation?
Your lordship,
our Contract Act section, I'll help you. Our Contract Act Section 63 says that the promisee may dispense with or remit performance of the promise. So our law does allow a promisee to dispense with or remit performance of the promise. So do you think Section 63 can either be of helpful in your case, or it would be the other way around?
your lordship, in our case, not 63, but 62 is applicable in this case.
Okay, so you think Section 63 has no application?
Yes, your lordship. As per my law.
But Section 63 clearly says that if one party owes the other some money, right, and other party makes a part payment, and if the first party accepts part payment, it might discharge the whole debt. Okay, so it might be of some relevance to your case in some situations.
Your lordship, there has been two considerations.
Okay.
Basically. So firstly, F. Rahman asks 18 lakh rupees for the timely restoration of the property. That's another, that's one. And the other is when there was this promisor, Sarkar, who asked for another 5 lakh. So there is this another contract.
Learned counsel, there are two different contexts here. One is the contract modification of someone asking for additional 5 lakh, which was agreed upon according to the facts. Okay. And then came the issue of accepting the lesser sum of money. And the question is, when you accept the lesser sum of money, when one party accepts the lesser sum of money according to our law, right, does it discharge the whole debt, the whole claim? And that is
Yes,
section
according
63.
a mere omission of his rights doesn't, but according to section 63, it does. But it's
Right.
a mere omission of right doesn't.
Right. And now one final question. Do you think promissory estoppel as a doctrine would suspend someone's rights or extinguish the rights forever? Can you simply forego the debt, part of it, and then come back and say, I want to make the claim because of the change of circumstances?
Your Lordship, the promissory doctrine, promissory estoppel doctrine says that a promissory estoppel would be applied in case of there is no consideration. Also, then also it will be applied. But in this case, but there are certain criteria which has been set by high risk case. We have to take into consideration that, and the 4 criterion which has been settled by the high risk case doesn't apply in this case. Moreover, unlike high risk case, this is different. Because in high risk case, there was a contract between the parties that they will let the block of flats to a certain half of the price. After the World War II was over, they claimed another. But there was no such thing in this case.
Land Counsel, you are absolutely on the point. This is my question. That is your situation is a high tree situation?
No, Your Lordship.
Is...
No,
Okay,
Your Lordship.
Why not?
Because I have already stated the reasons for not applying the.
No. It's not that the question I'm asking for. My question is very simple. Do you think that when someone forgoes a sum of money, part of the money, saying, okay, I'm not going to claim 30% from you at all, or I'm not going to claim 30% from you, do you think that right is lost forever? Or he can, under some change situation, under different situation, can come back and make that claim? So my question to you, that our contracting question here, is it a one-off payment or it is a continuing relationship between the parties?
If you see the two, if you consider it's a continuing one. Because Sarkar didn't say that he is not going to claim that money. He never said that.
Okay. This is the point.
It is his emotion that he didn't claim that way, and he was rather afraid that he might. It's clearly gave in the compromise that he was afraid that he might lose all of his money as he had invested so much.
Land Counsel, the project has been completed already, so there is nothing to continue between the parties. In the high trees, let me finish. The high trees case concerned a continuing landlord-tenant relationship. And that was subject to a condition that once the World War comes to an end, they may, by giving notice, claim the full amount later. But prospectively, not retrospectively. You see the point?
But Your Lordship,
in this case, the contract has come to an end. So there is no ongoing. That was my point, and that is the question. So do you think if someone forgives a part payment or part amount, is that right lost forever, or he can come back and claim?
But Your Lordship, the Sarkar haven't forgone his right. He has claimed it. He has sued before.
Thank you. Well done. Thank you so much.
Now, I'd like to request the appellant to submit their rebuttal.
May it please the court? Much obliged. Your Lordship, appellant has 3 points for the rebut. First of all, our opponent say, our learned counsel friends said that there had a valid contract which is alteration. But here is a undue influence which we reflect that on the paragraph number 2 of the connotation of the fact. In this fact, we see that the Afroman has entered into another contract by which he accepts 1,20,000 taka every month as rent. if he didn't complete the work of his building within 5th April, he can face losses. At that time, when K. Shankar said that he didn't complete his work construction within 5th April, he has got influence or that he can face losses. And after K. Shankar also know this. By influencing these things, K. Shankar demand extra 5 lakh takas for completing the work. So my client agree with these things, but there had an influence. And under Section 29A of the Contract Act 1872, we can say that this contract is not alteration of contract is not a valid contract because he can face undue influence on here. And another thing was said that our opponent, Learned Counsel friend, is that from the 10 kg Rasmalai, their client K. Shankar didn't get any practical benefit. But we can say that 10 kg Rasmalai is a very sweet thing, and by which anyone can get his enjoyment of his life. And K. Shankar also get these things. Because of these things, he didn't say anything in between 2 months, and he just enjoyed the sweets of Rasmalai. And these things is not countable by the money. By these things, we can also say that by our referring case, that the K. Shankar get financially benefit, but he can get practical benefit, which is reflected our case. So the sweet or Rasmalai give him the practical benefit. So we can say that the additional are benefited for him. Ourselves also can say that the promissory estoppel is not apply on here, because we can say that promissory estoppel apply one that time when the promisee relied on the promise. But here we can say that there had no additional promise on which the promisee relied on, because the second contract, alteration of contract, is not a valid. So if he relied on these things which didn't promise my client affirmation, so he had no responsibility if he faced losses. And if he faced loss, he can claim it before, but at the time of getting payment, he can say nothing which he get from the fact that he can get any objection, he faced losses. So we can also say that he didn't face any loss for his part. So we can say that the promissory estoppel is not also apply on the part for the getting additional payment for their client K. Shankar. So the appellant want to raise up the case on here by saying that the Honorable Your Lordship, please give the justice on the appellant equity, justice, and good conscience. Much obliged.
Now, I'd like to request the respondent to submit their sub-rebuttal.
Starting with the undue influence, which has already been proved by my co-counsel that it does not apply here, because in particular and without prejudice to the generally to the foreign principle, a person is deemed to be in a position to dominate the will of another, which is has been said in the section subsection 2 of the section 16 of the Contract Act. There has to be a fiduciary relationship, and also where there makes a contract with a person whose mental capacity is temporarily or permanently affected. So undue influence in no way applies here. And then I would like to say that they have talked about that promissory estoppel, However, already my co-counsel has proved that the 4 conditions actually applies in this case. And also in their page number 11, they're actually agreeing with us by referring the Combs versus Combs case. And in the page number 12, they have given some essential elements of promissory estoppel with no source, misleading the court. Thank you. And misleading the court with information with no source, and these are not actually the elements of a promissory estoppel. And they have also said in their page number 12 that they were in a worse position, which is not true, because our client has actually delivered even before the specified time, which was the 5th April, but he has delivered in the 2nd April. So this has proved that also in the William versus Sophie and AMWB case that they were benefited. And so it is practically benefiting. This is actually, they are giving actually wrong legal assumptions, or they're assuming by themselves, because a sweet thing is very this is actually not practical with the sweet thing, and not my client has actually demanded for it. They have given it by themselves, and this was a thank you. And in culturally also in our country, thank you very much. Also culturally in our country, giving sweets to others is just a gesture of thank you or a gift. So moving on, I have very short. Sorry to just point out in the page number 8, they have referred the Pinel's case and also the DC Builders case and People versus Nestle case, where it is said where the case was actually in favor of the Nestle because there was no economic value, monetary value, and the practical benefit, and there was no practical benefit as the wrappers had no monetary value to it. In the page number 9, they had no source and they have assumed fact and misled the court that the promisor that our client was jealous by the Facebook post. However, your lordships, in the fact, it is clearly stated that it was upsetting for him because the rest of the money was not paid, which is not discharged by any communication which is referred in the section 3 and 4 of the contract. I would just like to take 30 seconds to wrap up my sorry. Thank you very much. And also the exception of Steele versus Mike case has been given in the Hansen versus Roden case, Hartley versus Ponson case, and also in the William versus Sophie case. And in the page number 12, they have already talked about the undue influence. And most importantly, your lordships, they did not refer any Bangladeshi case in the written submission. They have many loopholes in the written submission. They did not refer any sources. They have also said in their oral submissions, Sarkar was angry. This is also misleading the court. Sarkar was never angry. It was upsetting for him because the rest of the money was not paid. And they have said analysis of many cases, but there was no sources of those cases. Where are those analyses? Where are the case laws? Where are the principles? And they said that he did not enter into the contract, which is also misleading because in the paragraph number 2 of the Moot compromise, Roman agreed to pay the 5 lakhs taka. This is clearly said.
Time's up.
Thank you very much. Therefore, I will rest my rebuttal here. Thank you very much.
All right. Now, I would like to give the floor to one of our faculty member, Mr. Farhan MD Arfsa, to continue the further activities. Thank you.
Thank you so much. Thank you so much, Payne. Honorable judges of the final round, Assalamu alaikum. I would like to ask for your clarification on one matter. That is, would you like to deliberate amongst yourself for 5 minutes before you mark, or would you like to do it independently without deliberation amongst yourself?
I'm happy with either options. I would leave it to my learned colleagues, whichever way you are more sort of comfortable. We can deliberate for 5 minutes, I guess, amongst ourselves. Is all right? Learned co-judges.
Okay, no problem.
Right.
We can go to a breakout room and then do it return ourselves and then come back.
Okay, sir. So you will see on your screen a message that says, "I'm requesting you to join a breakout room. Click join." Okay. I am putting you, all 3 of you, honorable judges, in a breakout room. The rest of the participants stay normally. Don't worry. You don't have to leave the session. Okay. We will come back. In the meanwhile, you will watch some videos, have some discussions. But honorable judges are going to miss that. Okay. So I am adding Advocate Kamruzzaman Bhuiya sir, Dr. Khaled Hamid Chaudhary sir, and Zakir Hossain Khan sir, along with I am adding a member of the organizing committee, 2 Fahims, and maybe Anunma. Yeah, I'll just add another one. You get a request on your screen, sir. You'll get a request on your screen, and you can click on that, and basically we will be in a breakout room. I can see that everyone is there, so I will take my leave. Please, Saleh sir and everyone, continue the session without me. Thank you. Sound, sir.
Farhan, would you like to say something here before we deliberate?
জি স্যার, জি স্যার, আমি বাংলায় বলি স্যার, সবাই যেহেতু এটা আমরা এখন ফর্মাল ইস্যু নেই। স্যার, আমাদের যেটা করতে হবে, there are 2 sheets, একটা হচ্ছে অ্যাপিলেন্টের জন্য, একটা রেসপন্ডেন্টের জন্য, এবং প্রত্যেকটা ক্রাইটেরিয়াতে কত করে মার্ক দিতে হবে এটা ওখানে দেয়া আছে। আপনারা একে অপরের সাথে ডিসকাস করতে পারেন যে কারটা ভালো লাগলো কারটা খারাপ লাগলো ডেফিনেটলি, বাট ইভেনচুয়ালি স্যার ইট উইল নট বি ডিসাইডেড অন 2 against 1 বা ইউনানিমাস। টোটাল মার্কসের বন্টনের ভিত্তিতে যে টিমের মার্ক বেশি থাকবে সে টিমকেই আমরা চ্যাম্পিয়ন হিসেবে বা উইনার হিসেবে এই রাউন্ডের ঘোষণা করব স্যার।
তাহলে আমার মনে হয় যে যেহেতু আমাদের এটা 2-1 বা এটা কোনো মানে মেজরিটি বা ইউনানিমিটি নাই, তাহলে আমরা বরং আমাদের মার্কিং গুলা করে ফেলি যার যা আমরা করে আপনাকে কি ইমেল করে দিচ্ছি, রাইট?
জি স্যার, ওই যে ইমেল থেকে আপনাদের লিংকটা এবং মেমোরিয়ালের ইনভিটেশনটা এসেছিল, ওয়ার্ড ডকুমেন্টটা ফিল আপ করে আপনারা সেভ করে ওই ইমেলে পাঠিয়ে দিবেন আপনারা যে মার্কটা দিতে চান। এতে যদি কোনো রকম কোনো সাহায্য দরকার হয়, এখানে স্যার অনন্যাকর অনু আছেন, জাকির স্যার, জাকির স্যার যদি কোনো হেল্প লাগে বা ভুয়া স্যারের জন্য হেল্প লাগে দিহান আছেন, আমি আছি, ফাহিম শাহরিয়ার আছেন। ইউ ক্যান ইনভলভ এনি ওয়ান অফ দেম টু হেল্প ইউ ইন এনি আদার ইস্যুস।
আচ্ছা, আপনারা কি এখন আমরা যখন এটা পাঠিয়ে দিব আপনারা কি আজকে উইনার ডিক্লেয়ার করে এসব শেষ করবেন না এটা পরে হবে?
আমাদের আর হাতে 40 মিনিট আছে স্যার, ক্লোজিং সেরেমনি সহ।
ওকে, তাহলে আমরা একটা কাজ করি, দেরি না করে আমরা বরং ডেলিবারেশনের বেশি না গিয়ে আমরা স্কোরিংটা আপনাদেরকে ইমেল করে দিই।
আমার প্রশ্ন হচ্ছে যে আউট অফ 20 বিভিন্ন ক্যাটাগরিতে নাম্বার আছে, সর্বোচ্চ নাম্বার কত দেওয়া যেতে পারে আর সর্বনিম্ন কত দেওয়া যেতে পারে?
স্যার 10 এর নিচে দিয়েন না স্যার, মানে ডু নট গিভ বিলো 50%, আর হাইয়েস্ট আপনি স্যার 20ও দিতে পারেন। এরকমও আমি কয়েকটা দেখেছি যে 15, 17, 19 এরকম পেয়েছে। মানে সবাই তো স্যার সবগুলা ফ্যাক্টরে ভালো না, কারো নলেজ অফ ল ভালো থাকে, কারো আপনার প্রেজেন্টেশন ভালো থাকে, কারো স্ট্রাকচার ভালো লাগে। আপনারা তো পুরো সেশনটা দেখেছেন, আপনাদের কমপ্লিট ইন্ডিপেন্ডেন্ট ইম্পার্শিয়াল বিবেচনায় যেটা আপনার ভালো মনে হয় স্যার আপনি দিয়ে পাঠান, বাট 10 এর কম দিয়েন না, এটা আমার রিকোয়েস্ট অ্যাজ আ টিচার।
না ঠিক আছে, এটা তো স্টুডেন্ট।
আমাদেরকে জাকির ভাই যদি এগ্রি করেন, আমরা 5 মিনিট সময় নেই, আমরা নিজেরা স্কোরিং করে ইমেল পাঠিয়ে দেই।
ওকে
স্টুডেন্টের জন্য কিন্তু ফরম্যাট
জানালে
আমরা we among just want to tell each other we among three just to
আচ্ছা,
sharing our views
এটা কি
each other.
কোনো দিয়েছেন আপনারা, কোনো ফরম্যাট দিয়েছেন যেখানে আমরা নাম্বারগুলো পুট করব?
জি স্যার,
হ্যাঁ, আপনার কাছে আছে, ওই ইমেইলে একটা দুটো অ্যাটাচমেন্ট আছে দেখবেন, ওরাল স্কোর শিট, অ্যাপিলেন্ট আর রেসপন্ডেন্টের দুটো স্কোর শিট আলাদা আছে।
স্যার আমি কামরুজ্জামান স্যার মেলে স্যার আমি মেল করেছি, আমি মাত্র যখন কম্পিটিশনটা শুরু হয়েছে আমি তখন আবার মেল করেছি স্যার, একটু মেলটা চেক করবেন।
আমি দেখে নিচ্ছি। জি।
আর স্যার আপনি যদি মনে করেন যে আমাদের টিম মেম্বার একজন ফোন করে আপনার থেকে ওরালি রেকর্ড করবে, সেটাও স্যার সম্ভব স্যার।
আচ্ছা ঠিক আছে, আমি দেখে নিচ্ছি, না হলে আমি ফোন দিয়ে জানাচ্ছি, অসুবিধা
স্যার তাহলে স্যার আমরা নেক্সট 5-6 মিনিট এখানেই থাকি স্যার, তারপরে আমাদের শেষ হলে রেজাল্টটা তারপরে আমরা আবার ওখানে জয়েন করব স্যার।
ওখানে কি আমাদের কি ওখানে কিছু বলতে হবে না, মানে ডুফলস গুলি ড্রব্যাকস গুলি কি বলার স্কোপ আছে না বললেও চলবে?
না স্যার, আপনাদের ছোট একটা ফিডব্যাক স্যার আমরা প্রত্যাশা করি, যে আপনাদের কার কোন সাবমিশন ভালো লাগলো বা কিভাবে তারা ইন দা ফিউচার তাদের অ্যাডভোকেসি, জাজের সামনে কথা বলা, তাদের স্ট্রাকচার, তাদের সাবমিশন ইমপ্রুভ করতে পারে। আমরা স্যার এক্সপেক্ট করি আপনারা দুই একটা কথা বলেন স্যার, ফিডব্যাক দেন, এতে ছাত্রছাত্রীদের একটা পজিটিভ কনস্ট্রাকটিভ ডেভেলপমেন্টের পক্ষে এটা একটা মানে কি রাখে স্যার। 1-2 মিনিট যদি আপনারা এই সেশনটা মানে রেজাল্টের পরে 1-2 মিনিট স্যার যদি একটু বলতেন খুব খুব ভালো হতো।
রেজাল্টের পরে না আগে?
রেজাল্টের পরে স্যার, আপনারা আগে রেজাল্টটা দিয়ে তারপরে আমি আপনাদেরকে আবার মানে মেইন স্ট্রিম যে ফিডটা আছে সেখানে নিয়ে যাব, সেখানে আপনারা একটু কথা বলতে।
ওকে ওকে, তাহলে আমরা আমাদের রেজাল্ট শীট তৈরি করি।
জি স্যার।
ডক্টর খালেদ চৌধুরী কি বলেন?
ওকে, রেজাল্ট কিন্তু ভাই, রেজাল্ট কিন্তু আমাদের প্রত্যেকের ইন্ডিভিজুয়াল পয়েন্ট ওরা আবার যোগ করবে।
জি, আমাদের মতো করে দিয়ে দিতে পারে, তো
সময় কম, তো আমরা বলি আমাদের মতো করে দিয়ে দিই, কি বলতে ভালো হবে, তাহলে ওকে।
স্যার আপনাদের যে কোনো সাহায্য লাগলে আমাদের সাথে শেয়ার করবেন স্যার, উই আর হিয়ার টু সার্ভ ইউ। আচ্ছা ফাহিমের দরকার নেই, আমি ফাহিমকে মেইন রুমে পাঠিয়ে দিচ্ছি, মানে ফাহিম শাহরিয়ারের।
জাকির স্যারটা আমি পেয়েছি স্যার।
জি ফাহিম।
জাকির স্যার আমাকে সেন্ড করে দিয়েছেন স্যার, পেয়ে গেছি।
আচ্ছা দুইটাই তো ফিল্ড আপ না?
ফাহিম আমিও পাঠিয়েছি, ক্যান ইউ চেক প্লিজ?
ইয়েস আই এম চেকিং স্যার।
ফাহিম দুইটাই আমাকে ফরওয়ার্ড করেন আমার ইউএপি ইমেইলে।
আর রিচেক করে দিন তাই।
স্যার স্যার জি স্যার, ফাহিম দুটোই আমাকে ফরওয়ার্ড করেন স্যার।
Have you got Fahim?
ইয়েস স্যার, স্যার ফাহিম পেয়েছে স্যার, হি ইজ চেকিং রাইট নাও স্যার।
Okay.
কিন্তু স্যার খালেদ স্যার, আই এম টেরিবলি সরি ফর ইওর লস স্যার।
ও না না, এটা পরে করবো।
আরব স্যার আমি দুইটা আপনাকে পাঠিয়েছি।
জি আমরা তাহলে আর কামরুজ্জামান স্যার পাঠালেই তিনজনের টেক হয়ে যাবে। আমরা আরেক 1-2 মিনিট দেখি স্যার পাঠান, আমি চেক করতেছি ফাহিম। জি আমি আপনার দুটো ইমেল পেয়েছি, জাকির স্যারেরটা পেয়েছি। ওকে রেসপন্ডেন্ট দুইটা ওরালে।
Within 2 minutes, I am sharing the marks. Okay.
Sir.
Within 2 minutes.
জি স্যার। আর স্যার আমাদের এমনিতে আমাদের অনেকেই কিন্তু এখানে ফার্স্ট টাইম মুটার স্যার, আশা করি আপনাদের সাবমিশন ভালো লাগছে স্যার।
না ভালো করেছে, ভালো করেছে।
They have done well. They have done well apart from some loopholes. Okay, no problem. By experience, they will get much more skill. No problem.
Thank you so much, sir. Thank you so much. আর পেয়েছি খালেদ স্যার এবং জাকির স্যারটা পেয়েছি, আই চেক সবগুলা ঘর ফিল আপ আছে, এভরিথিং ওকে স্যার। এখন এরপরে স্যার এডিশন করে বোঝা যাবে স্যার যে হু ইজ দা ভিক্টর।
হ্যাঁ সবার ট্যাগ করতে হবে আপনাদেরকে
স্যার। বাট ইন্টারেস্টিং জিনিসটা হচ্ছে স্যার, এখন আপনাদের বলি যে এখানে কিন্তু স্যার একটা টিম এলএলএম এর একটা আন্ডার গ্রাজুয়েট।
ওয়াও, ওকে, আমরা বুঝি না যদিও, which is good.
এবং স্যার একজন কিন্তু এখানে ভারতীয় নাগরিকও পার্টিসিপেট।
The last lady, I guess.
জি স্যার, জি স্যার, জি স্যার। উনি আমাকে একটু আগে এসএমএস করছে হোয়াটসঅ্যাপে যে স্যার আই এম অঙ্কিতা, প্লিজ ক্যান ইউ টেল দিস পারসন টু মিউট, আমাদের শব্দ আসতেছে। তো আমি নাম্বারটা যে দেখি যে এটা +97 ইত্যাদি কেউ একটা নাম্বার, পরে আমি আই ডিড দ্য ম্যাথ, আমি লাইক ও আচ্ছা ঠিক আছে, তাহলে মনে হয় ইন্ডিয়ান। আমি এর আগে জানতাম না স্যার। আবার সেমিফাইনালে স্যার একজন নেপালিও ছিল, উনি আমাদের স্টুডেন্ট স্যার, ওই যে আপনার ইউএমসিএলস প্রোগ্রামের ছাত্রছাত্রী, অনেক মানে সার্ক কান্ট্রি থেকে পপুলার স্যার প্রোগ্রামটা। খালেদ স্যার তো জানেন স্যার, আমি তো নিজে ইউএমসিএলস অ্যালামনাস স্যার, আপনি তো জানেন স্যার। ফাহিম ল্যাপটপের সামনে থাকেন, ভুইয়া স্যার পাঠাইলে আপনি আমাকে জানাবেন এবং ফরওয়ার্ড করবেন। আপনি হিসাব করা শুরু করে দেন ফাহিম, আপনি এডিশন করা শুরু করে দেন, বুঝছেন?
স্যার আমি করছি স্যার, একটা অলরেডি শেষ স্যার।
হ্যাঁ, ভেরি গুড, ভেরি গুড।
ফরহান ভাই, আপনার মনে হয় ওই স্যারের পারমিশন নিয়ে আমরা একটু নিজেদের কথাগুলো সেরে নিতে পারি। আমি অলরেডি পাঠিয়ে দিচ্ছি, রেডি হয়ে গেছে। আর আমার একটু পার্সোনাল ব্যস্ততাও আছে, আমাকে 8:30 আরেকটা মিটিং এ জয়েন করার কথা ছিল। আসলে এখানে যদি আপনারা পারমিশন দেন তাহলে আমি
জি স্যার,
ওদের অ্যাবসেন্সেই আজকে আসলে এই প্রোগ্রামটা আমার পার্টিসিপেশন এই মোট কোডের সেশনে, মাই ফার্স্ট সেশন, ফার্স্ট অ্যাপিয়ারেন্স। Dr. Khaled Hussain sir has much experience. Amra এটা we have understood the matter. Actually, since this is my first experience, both the parties have done very good, and before coming to the court, actually they have done very well. In our academic life, we did not get such kind of opportunity to for placing any fact, particularly the fact regarding moot court. We did not get such kind of opportunity. I must appreciate you for arranging such kind of good uh, arrangement actually, and both the sides have done good, very good. And particularly, I in my from my particular from my side, I think the respondents side have done their case very well, and the respondents have placed their case wonderfully, and their argument is good, and the presentation also was good, very good, and lawfully they have also argued very uh, clearly and wonderfully. So I think the in the appellate division, the respondent should win and the appeal should be dismissed. This is my view. And if you kindly allow me, I may leave and please share the
Thank
matter.
you, thank you. It was a pleasure. আপনি অনেক ভালো সুন্দর প্রশ্ন করেছেন, I must say. So ওরা টেস্টেড হয়েছে কিন্তু। Thank you. আবার দেখা হবে ইনশাআল্লাহ।
Okay, thank you, sir.
আপনি পাঠিয়েছেন স্যার?
Yes, I have sent it.
রেজাল্টের ব্যাপারে কিন্তু আমিও আপনার সঙ্গে ইন এগ্রিমেন্ট। So it's okay.
Thank you, sir. I have sent it already. Have you got it?
Fahim, did you get
Fine,
it?
sir.
Yes, sir. I got it.
Okay, sir. Thank you so much. But sir, I will be expecting Khaled sir and Zakir sir to say a few words, sir. If it's
Okay, thank you. Assalamu alaikum.
okay, sir. তাহলে আমি স্যার আপনাদেরকে আবার একটা রিকোয়েস্ট পাঠাবো, ইউ আর গোনা গেট আ রিকোয়েস্ট টু মুভ টু দ্য মেইন সেশন, ওটা একটু অ্যাকসেপ্ট করে দিন।
As may I leave with your all of your permission? May I leave?
Okay.
Thank you.
Assalamu alaikum.
একটা রিকোয়েস্ট পাবেন স্যার, অ্যাকসেপ্ট করে ফেলেন।
ওকে, অ্যাকসেপ্ট করে নিচ্ছি।
Assalamu alaikum, everyone. So it was a very long and arduous phase of deliberation, discussion, and basically judges doing their thing, and they were really good at it. And with that being said, we have successfully collected the opinions and the scoring of all the three judges. I believe I'm audible, right? I'm in the main room now.
Yes, sir, you are.
Okay. So we've received the marks. So our team will be compiling the marks, and soon we'll be able to come up with a definitive and conclusive end to the competition, that which team has prevailed over the other. But in my eyes, as one of the persons working closely with organizing this competition, in my eyes, both of you are winners and champions, and nothing can change that. But obviously it's a competition, so as it's a competition, there has to be a winner, and there has to be someone who's not a winner, but they're still up there. Undoubtedly you guys are the top two teams of Asia Pacific, and there's nothing that can change that. So we've already had this discussion. I'm sorry, I'm just repeating myself like a broken record. So don't get disheartened, and we still have many other opportunities, both in home and abroad. Many competitions are coming, so we will test our mettle in those places and competitions and prove to be worthy, both in the national and international level. But this is our university-wide level, so thank you so much. So with that being said, I needed to share a few more things. Before I continue with the session, I want both the honorable judges to give their feedback on the participants that they have currently adjudicated. I don't know who should go first.
Let Mr. Zakir Hussain Khan start.
Okay.
Thank you.
Okay, thank you to all. With due regards to all, including our learned co-adjudicators, I would like to say something about the session. Before going to the comment to the council, I express my gratitude to the organizer, especially the convener who informed me for being adjudicator of the moot court competition. I feel honored and delighted. I also extend my thanks to the virtual attendant here who lively enjoyed and shared the views in this session. Now let me tell about the council or the learned advocates for the both side. In a word, if I tell, both the team have done very well. In different sectors, they have done well. However, I think there are some loopholes between them and both the parties. Since this is a contractual matters and this is a contract law, there are some other terms should come here. As for example, supervening impossibility, the provisions of applicability in Bangladesh, the promissory estoppel, which are to be more clear, are to be made more clear. There are some other matters, like we know that the contract law in our country are not only mere laws, it is also based on equitable principles. You know that the person who comes to court must come with clean hand. He who seeks equity must do equity. there are some other words that should be discussed here, like part performance, non-performance of which is inevitable, or the performance of which is not inevitable. Some other words like irreparable loss, whether non-performance of contract which is irreparable loss to the one party or not. This is also should come into consideration of this discussion. And another one is that Dr. Khalid Chaudhary is very much well known to it, that in Bangladesh context, case law is important, no doubt, but in our contract law, we only discuss about the British law, British case law. Here, we should come into contact with the Bangladesh case reference, because the Bangladesh apex court rulings are binding to all subordinate courts in our country. This has authoritative values, whereas the doctrine which we referred here are from British laws, which are not authoritative values in our countries. So in this regard, we should come forward for knowing as a whole about the variation of contractual obligation in our country. However, apart from this, both the teams, I can boldly say that done very well, and nowadays it is a moot court competition. I think in the field, that means in the appellate division or in the court premises, they will done more well. So thank you very much to all. Thank you.
Thank you so much, sir. Thank you so much for your lovely feedback and your opinion. It means a lot to us, especially to the aspiring mooters who can take a lesson from your feedback. Khalid sir, Dr. Khalid Ahmed Chaudhary sir, Honorable Adjudicator of the final round, I would like to give you the floor to give some feedback on the students and what you thought overall, sir. Thank you.
Thank you. First of all, I also again I thank the UAPMCC for inviting me to be an adjudicator in the final. And I know some of my colleagues have already adjudicated in the earlier rounds, and they have all expressed their satisfaction, and my view is of the same. I think it was excellent. Firstly, as I understand that this is one of those opportunities students you get during your academic life to get a feel of what it would be in a court or real life scenario, and that's very important. Particularly during the pandemic, when we are actually struggling with COVID-19 for the last 18, 19 months or so, we have all gone virtual, and we are all learning new things. And it has been very challenging for the profession. And, many chambers have shut down, and the legal community have been suffering. And it has simply been enhanced by our sort of say infrequent holding of the Bar Council examination. We all know that it's a big struggle for you. So the message is do not lose even a simple opportunity to learn. Okay, so whether it's a 2-day competition, a 1-day course, whether it's on VAT, income tax, adjudication, mediation, go for it. I think it's a blessing in disguise because the pandemic has opened the door when the world is the limit. So you can all participate globally. You can invite people from all across the globe, and you can listen to them, you can view them, But having said that, coming to this particular moot today, I think you all did exceptionally well. It is never easy to make a deliberation in a foreign language, particularly when you are actually you are being shown in Facebook Live and stuff, and the nervousness is nothing, not a surprise. But I must congratulate both the teams because as a judge, it is never an easy task to adjudicate in a virtual situation because when you are face to face, you can see the body language, the demeanors, and the eye contact, and the way you present your arguments and counter arguments. You can see the nervousness and also the boldness. But in the virtual scenario, it's extremely challenging for the judges as well. And sometimes it becomes monotonous. Although we have all our notes and books around, which makes it perhaps more comfortable subjectively. But I would like to adjudicate in a real courtroom. So having said that, I will not take any credit away from you people, simply because that our law, I mean, the scenario that has been created, I don't know who wrote the problem, has done a wonderful job, simply because the law in England itself is not yet settled. So and basing on a scenario where our Contract Act differentiates to a large extent or to some extent to an English law, right? So I would what I would pass a comment on, please also give equal attention to our local laws, like my fellow adjudicator has said, because try to figure out which particular section or provision of Contract Act would apply in each of the scenario, or they are applicable at all, right? You see, the beauty of it, the British, they have yet to codify contract law, and whereas they did it, I mean, 150, 60 years back. Isn't that amazing? I mean, they have defined proposal and consideration and this and that, and still they are at common law in 2021. You know, you need to learn the name of the cases and not the section numbers, because it's flexible. Now, coming to this particular question quickly, you see, I deliberately asked a question because the first one, that whether payment of a lesser sum by the debtor, you know, would actually, and some additional, like the 10 kg Rashmalai. Farhan loves sweets, I know. I don't know whether it was his idea to add 10 kg Rashmalai, okay? So sufficient consideration for creditors, you know, promise to forego the balance of 3 lakh was a very interesting one. So you see, this problem started with a payment of a greater sum. It was not a payment of a lesser sum problem, because the contract was for 18 lakh. And then they negotiated to 23 lakhs because they said we have a financial difficulty. And the owner agreed reluctantly, right? Reluctantly agreed. So question is whether then, if you talk about the lesser sum of money in the first place, it's slightly confusing. So I would say the lower court judge and the high court, I would say, probably paid attention to that. And of course they said, okay, I mean, we are for the claimant, the plaintiff. And now the plaintiff become respondent because they won in both the courts. And you should be mindful of that as well, who's who and who's arguing what. So my point is that this is not really a penal situation to start with, but this is payment of an extra amount of money. And whether, if you, like one of you, I think very nicely argued that this is a pre-existing duty situation to do something. And if one party simply says, please pay me 5 lakh more for doing the same job, what has he done extra by doing the same job? And this is the question here. I mean, in a way, nothing, because I was contractually bound to perform. I was contractually bound to perform the job by the 4th of April or something like that, right? So I did the same thing. Why would I get 5 lakh more? So, you know, this was more or less the Steel versus Merrick, Hartley and Ponsonby, all settled for a long time. And then came Roffey Brothers, disturbed the scenario. And Roffey Brothers came back to say, no, in this situation, we have to think of the 1990s. We're not yet in the Steel versus Merrick situation when the sailors would desert the ship. And that was an entirely different context. Sailors deserted the ship, renegotiated with the master. And Roffey Brothers is more, 20th century thing, because it can happen in the real world that I sign a contract and I promise that I will perform the job for, let's say, 30,000 pounds or 30 lakh taka, and suddenly I'm in trouble, so I need more payment. That is contract modification, you know what I mean? So Roffey Brothers said that, you know, by giving practical benefit, right? Practical benefit is a consideration moving from the promisee. But many have questioned that what did they do? I mean, practical benefit they conferred on the other side, but this was something they were supposed to do anyway. So Roffey Brothers is a remarkable case, challenged in a number of cases. However, when you talk about Pinner's case is about payment of a lesser sum of money against a claim of greater sum of money. So I owe you 100, right? And you simply say, pay me 80, we are cool, we're fine. So if I accept, if 80 is accepted, then can you simply, you know, come back against me saying, I want 20 more? Now, Forbes versus Beer penal cases said no, you can't, because common law doesn't support lack of consideration. Then comes Lord Denning, equity, high trees, later development saying no, it is inequitable, unconscionable. Therefore, the promisor should be stopped. Right? So this problem quite beautifully shapes from Roffey situation to Pinel's case afterwards. So, you should have stuck to your submission separately, rather saying two contracts. Why not is one contract being modified or substituted? This is what I mentioned about section 62 as well as 63, because 62 talks about one thing, 63 says one can forego 60% if the other side agrees and I agree, I lose it forever. That is Bangladesh law, section 63. So slightly different from common law. It's a departure from common law. And also in our law, consideration does not need to move from the promisee at all. I think you know all that. Because our definition of consideration under section 2D of the Contract Act, it doesn't require that it must come from the promisee. It can come from anyone. And also in our law, past consideration in some cases can be good, provided there is a request coming from the promisor. Right? So there are certain differences between English law and Bangladesh law, which I'm pretty sure your tutors are teaching you very ably, and they will try to bank on that. So these are the three things. So, and also, most of you missed the point that one of my fellow adjudicators have said, what about not coming with clean hands? And this guy went for a holiday in a 5-star hotel and stuff like that. And he in the end, he said, look, you see, financial difficulty in April, in the month of April, might change and you might get a windfall somewhere in May. So he took his family out to Cox's Bazar in May. But the question is, due to the change of circumstances, can the other side come back and say, hey, you have a change of situation, so pay me my 3 lakh now. So you see, the facts are not clear. Whether they were in genuine financial difficulty in April, they could be. And what happened all of a sudden, they were spending a lot of money in the month of May with his family, right? So can your spending a lot of money in May make me come back and claim 3 lakh from you? This is why I asked the question, do you think promissory estoppel will extinguish your claim or suspend your claim? Because if my claim is suspended, then I can always come back and say, change of circumstances, pay me that. But if my claim is extinguished, gone forever, then I cannot really come back. Now, high trees, tool metal versus tungsten, rock, these were like continuing relationship cases. But this one is a one-off case of supplying and constructing a building. So much credit goes to both the teams, because we asked some difficult questions and you all did remarkably well. And definitely the context was very closely fought. I commend organizers and all of you. And I would urge through the UAP Mooting Club, all the universities, all the mooting clubs to actually come together, have more grand competitions, inter-university, why not? I would love to sponsor you and support you all in due course if you get the opportunity, because this is how I think you are the future. You are the future of the profession, right? So we must train you as best as we can. But you need to lead the country in future so that the right people can lead the country in the right place. You know what I mean? So I would not go into that further at all. But what we need is knowledge, honesty, sincerity, and integrity in the profession, in every sphere of our lives. In that way, we can fearlessly live as a lawyer. Okay, thank you so much.
Thank you so much, sir, for your lovely words. I mean, I agree with you 100% on the next generation and us being academics and teachers and our responsibility to pass on the medal to them. And I am also pleading guilty to your charge of Rashamalai, maybe because it probably had something to do with me, sir. So thank you so much. I mean, I got caught red-handed because you know me so well. So finally, we are almost at the very last portion of this closing session. We've already heard the honorable judge's feedback on your performance, on the moot problem, on the organization of the event, and we've heard two parties plead out to the best of their abilities this appeal that was heard in a fictional appellate division of the Supreme Court of Bangladesh. And the judges have deliberated. Our team has almost they've compiled the scores and sent the results to the authorities. But before the results, I would like to invite our chief guest, Dr. Chaudhuri Ishaq Ahmed Siddiqui, to say a few words and then declare the results. Sir, the floor is yours, sir.
Thank you, Farhan sir, for giving me the floor. Firstly, I want to thank all the honorable judges for taking the time to come over here and adjudicate and give their very valuable feedback to all the participants. I thought the comments and the feedback they have given will be extremely helpful to all the mooters. I thought the quality of mooting was really good. And I think both the teams have done really, really well. And I think especially the team from the fifth semester, you guys have done exceptionally well, and you are actually fighting against a team which is in the master's program. So LLM fighting against LLB. So despite that, I feel you have done exceptionally well. As I think Dr. Khaled Hamid Chaudhry said, Dr. Zakir Hussain said, and Kamruzaman sir said as well, that you guys really answered their question properly, but there is still some room for improvement in the sense that when you were quoting the case law, and Khaled sir especially asked you a question whether this has actually gone to the Supreme Court, and you couldn't answer. So you need to do your due diligence properly. So you need to do your research properly in that regard. And I personally feel the purpose of having this kind of competition is to give you guys a flavor of what to expect when you guys go to the practice. All right. When you go to the practice, things are not as rosy as it seems right now, because you have to think on your feet. You have to answer the questions that the judges are asking you. And at the end of the day, whatever you learn in your books, if you are not being able to deliver on those knowledge in court or help your client, then it is definitely not going to be helpful. So I hope that you take all their very valuable feedback on board. I hope you try to improve yourselves further and then represent UAP in a different mooting competitions in Bangladesh and abroad, right? So should I just give the results for answer?
Yes, sir.
Right. So I think it was an extremely close result. I think the fifth semester team got 467 and the UM sales team got 475. So it was just a matter of 8 marks. So I think both the team are the winners. Both of you guys are winners. Both of you guys have done exceptionally well. And I want to congratulate all 6 of you for doing really well. And I want to thank all the participants, all the 12 teams that has participated from the first semester till the master's program. I want to thank all of you. This is just the beginning. We're going to do this every semester. And inshallah, I hope that we're going to get more feedback from the judges. And I want to thank the organizing committee. Saleh Akram sir, Farhan sir, together with Sajjad sir was there, Farzana madam was there. All of you, thank you so much for your hard work. And I hope to see you guys soon in the future. Thank you. Assalamu alaikum and good evening.
Thank you, sir. Thank you, sir, for your kind words. And I'm glad that you think that our mooters did well, which I think is a positive sign. With that in mind, there are some more awards that we have to give out. So we will be taking 2 minutes to calculate one award, and then I'm going to give the floor to first to Sajjad sir to announce the best researcher, and then to for the best mooter, and Farzana ma'am for best researcher. I just need 2 minutes to double check the marks before I come back. Sir. Okay, okay. So extremely apologetic because we have to wrap this up at 9 p.m. So I don't want to take any longer. We are still done, but we have to still do some calculations because there are so many marks and the organizing team are overwhelmed. A lot of calculations need to be done. We don't want to make any mistakes. So we would just announce the best researcher right now. The best mooter and emerging mooter, 2 awards will be given within this week after publishing the score sheets. So we'll take some time on that one. So I would invite upon to speak and declare the best researcher award, Farzana ma'am. Farzana Akhtar ma'am.
Am I audible?
Yes, yes ma'am.
Thank you for giving me the floor to announce the best researcher's name. The best researcher of the 4th Intra-Department Moot Court Competition 2021 is Maliha Zemi from Team 407. Congratulations.
Mali, are you here? Okay. So
hello, hello, sir. It was really amazing hearing that. I would like to congratulate the winning team, and yeah, that's all. I'm just glad to hear it. Thank you, sir.
Excellent work doing research, Maliha. It's researchers like you who are the foundation of a good team.
Sir, I would like to include that it's not research is not only was based upon me, it was actually a group work. Fahad bin Siddiq and Padma Rizal, they actually contributed a lot. I mean, I just thankful to them, both of them.
Thank you so much. So congratulations to Padma and Fahim as well. You guys deserve it. Best researcher.
Thank you, sir.
All right. So with that out of the way, we will be announcing the best mooter and best emerging mooter with your photos in the Facebook group. And I'll personally make sure all the honorable judges get to know that in an email. And with that being said, I would now pass the podium to Mohammad Saleh Akram sir, the convener of UAP Moot Court Committee, to give a vote of thanks and conclude the session. Thank you so much, everyone. I'm signing off.
Thank you very much, Farhan sir. So it's an honor to have been asked to offer a vote of thanks on the occasion of the final round and the closing session of the 4th Intra-Department Moot Court Competition 2021. On behalf of the Moot Court Committee and the club here, I am very hearty gratitude to all the audiences present the last 2 days of the competition, and I want to thank the chief guest who gave his valuable time to grace the occasion. I want to thank all the adjudicators for giving their valuable time to us and adjudicating the competitions and giving valuable feedbacks. I also want to thank all the faculties for their cooperation. Further, a big thanks to Farhan Mohammad Araf, lecturer of Department of Law and Human Rights, and Fahim Ahmed, president of the UAP Moot Court Club. And I would like to place my hearty thanks to all the volunteers because of whom we made this possible. We thank you for being with us. Good night. Thank you.
Thank you so much, everyone. The results will be posted in the group, so keep your eyes on the page. And we also went live on Facebook. So if you want to watch this again in the future, you're most welcome to drop us a like at UAP Moot Court Club's website, Facebook page, and stay connected with us. Thank you, everyone, for joining. Thank you so much.
Thank you so much, sir.